U.S. Supreme Court denying a preliminary injunction motion to try and block the state's gun and magazine ban while the case plays out on the merits. What does this mean? I'm not an attorney, but I'll do my darndest to let you know what it could mean, especially when it comes to other litigation against the state's gun and magazine ban. Still pending in federal courts, because the issues central to the question of the Second Amendment have yet to be fully litigated. Back at it, Bishop on air here each and every weekday morning. Thanks for hanging out. And on this Friday, we've got a lot to tackle. Let's take a look at the Supreme Court docket for the case out of Naperville, where Robert Beavis and Law Weapons sued the city of Naperville first back in late 2022, and then they included the state whenever the state enacted a gun and magazine ban on January 10th. So you've got the case going all the way through the Northern District of Illinois. Northern District judge siding with Naperville, siding with the state of Illinois. They then went to the 7th Circuit U.S. Court of Appeals. But before that, the Naperville plaintiffs actually went to the U.S. Supreme Court to try to get an emergency injunction, claiming that they were being irreparably harmed. Right, and that's one of the key issues. If an injunction is to be issued on a emergency basis, you have to prove that you're being irreparably harmed. So, there's a few other factors involved too that lawyers have to try to prove to a court when it comes to trying to get that type of emergency relief. So you actually did have Naperville attempt to go to the U.S. Supreme Court Justice Amy Coney Barrett before the 7th Circuit Court of Appeals actually took the case earlier this year. And the U.S. Supreme Court sat on it for a moment, and then when you had the Southern District of Illinois with a different ruling than the Northern District, the Southern District actually gave a preliminary injunction, a temporary hold of the law while the case played out on its merits. That went to the appeals courts, where the appeals court immediately after 6 days, after being asked by the state of Illinois, the appeals courts put a temporary reversal on the Southern District's temporary blocking of the law. Right. So you had the 7th Circuit combine all these cases, but then you had Naperville with their first request to the U.S. Supreme Court ultimately denied after the appeals court, the 7th Circuit U.S. Court of Appeals, lumped all these cases together and said, we're going on a rocket docket, and then they heard the case. So the U.S. Supreme Court felt that the process was playing out. This was 6 months ago. And then you had the 7th Circuit U.S. Court of Appeals hear the case. 4 months later, they issue a ruling. And what they did is they vacated the Southern District's preliminary injunction, essentially just erasing it. And they said that the state has a likelihood to succeed on the merits. And I think that this is, again, extremely important because, even though the case most recently, the U.S. Supreme Court denied the Naperville plaintiffs an emergency injunction, that was based off of these preliminary steps. We have yet to get to the merits of the case and whether or not you can ban commonly owned firearms under recent U.S. Supreme Court precedent. Heller, Bruin, boards just go back to the 1790s and the Second Amendment of the United States Constitution. So regardless, you had the appeals courts side with the state, and then you had that was just a 3-judge panel of the appeals court. Then you had plaintiffs ask the full appeals court to give an en banc or the entire appeals court to review it. That was never guaranteed. So in between getting the denial on that and yesterday, you had the Beavis plaintiffs go to the Supreme Court and say, we need emergency relief while this case plays out on the merits. So when you look at the yesterday's docket entry, you do have the application referred to the court. Justice Amy Coney Barrett referred it to the court, and then the writ of injunction pending certiorari presented to Justice Barrett and by her referred to the court is denied. I think this is important. A writ of injunction pending cert. So this wasn't a denial of the case on the merits. This was just a denial of an immediate injunction, an emergency injunction pending cert of the court. So if you even look at the plaintiffs and what they told the Supreme Court justice on December 11th, they spell out that they let me get this right here. I've got myself looking at myself here. You've got the plaintiffs telling Justice Barrett that applicants are noting that the application that they had filed for a petition for rehearing en banc with the U.S. Seventh Circuit Court of Appeals earlier today, in the circuit court and the appeals court entered the attached order denying the petition. So that was all part of this as well. So now that you have the petition for the entire appeals court denied, the U.S. Supreme Court essentially denying an emergency injunction. Hannah Hill, I do hope to connect with her at some point later on this morning, and we'll share that conversation with you if we can possibly even connect live. I don't know if we can or not, but later on I'll be able to talk with her. But she posted on social media, she's with the National Association for Gun Rights. She, of course, posted the Supreme Court denied our emergency appeal, hopefully because they're waiting for our official cert petition. The court's taken serious notice of this case twice, and we look forward to giving them the opportunity to weigh in on the merits. So that was some initial reaction. You also had reaction from the Gun Violence Prevention PAC, GPAC. They released a statement from John Schmidt, former U.S. Attorney General, who's a member of their executive board. This is a gun control advocacy group. John Schmidt said that gun rights groups continue to try to block the new law after repeated failures, and they continue to get nowhere. They asked the Supreme Court for relief before the Seventh Circuit Court of Appeals ruled on the new law, and the Supreme Court said no. The gun control group went on to say now after the Court of Appeals has upheld the law, they've gone back and asked again. Not surprisingly, the Supreme Court again said no. They finished their statement saying no amount of flailing around by losing attorneys alters the basic fact the sale in Illinois of these destructive weapons continues to be blocked completely. So that was a statement from gun control group GPAC. But you gotta be careful when you're saying they shot down the challenge. No, they just simply said no. We're not going to preliminarily give this emergency relief while the merits play out. The merits are still playing out here. Rob Romano on X, he posted this. He said they asked for an injunction pending the result of their en banc petition, which was subsequently denied. So not exactly surprising. And they note, part of the filing here, where they show that specifically plaintiffs move for the courts for entry of an injunction restraining enforcement of the challenged laws pending the disposition of their petition for rehearing en banc in the Seventh Circuit and the filing of disposition of any follow-up petition of writ. So again, this isn't based off the law. This is clearly something that is based off of these requests for emergency action. So you have all of that at the U.S. Supreme Court, but then you also have in the Southern District of Illinois, we could have a ruling today on that. And this is a motion for a preliminary injunction against the January 1st deadline to register firearms. We covered that. If you missed the coverage there, check out some of the previous videos just in the past few days here with Bishop on Air on the YouTube channel, Bishop on Air. You can get all the links you need, bishoponair.com. But regardless, you can see, even looking at my Twitter page, the oral arguments that happened Tuesday in the Southern District of Illinois, and even during a status hearing on that challenge, Judge Stephen McGlynn said, listen, what the Seventh Circuit Court of Appeals dealt with was the gun ban issue, all right, and that's kind of what they're also dealing with the U.S. Supreme Court with litigation still ongoing. But in the Southern District this week, they heard oral arguments about the gun registry. So those are two different things, the gun ban and the gun registry. So we could possibly even today get something from the Southern District of Illinois to indicate, are we going to see a motion granted for an emergency injunction on the January 1st deadline, or are we going to see that motion denied? Now, Judge Stephen McGlynn just about promoted him, but Judge Stephen McGlynn, he did say he's inclined to not issue that injunction, saying it would make things even messier. But here we are. We've got less than 2 weeks before that January 1st deadline. Things are pretty messy as is. So we could see the Southern District issue some kind of ruling either today or early next week. I'll be glued to the pacer and refreshing, so we'll try to get that out to you as soon as possible once that happens. But just the top line here, the U.S. Supreme Court's denying denying an emergency request for an injunction against the state's law from the Naperville plaintiffs. And again, that was just pending cert. So yeah, it's just on that emergency injunction, has nothing to do with the merits of the law. But you also have, listen, Dan Calkins' case, even though an application was denied, and this was the case where Dan Calkins in the Illinois Supreme Court lost, but that's after he tried to get justices in the Illinois Supreme Court to recuse themselves because they took large campaign contributions from leaders of the other two branches of government. The U.S. Supreme Court, while they denied a motion to stay the law, which means to block the law's implementation while the case plays out in the U.S. Supreme Court, that was denied, but you still have Calkins' case very much alive and distributed to the Supreme Court conference. So even though you've got the denial of an emergency injunction in the Naperville case, you still have the Calkins case in the U.S. Supreme Court distributed for conference. So we'll see what happens there. That's going to be on January 5th, whenever they have their conference. So listen, we're far from any kind of finality on any of this. So I appreciate you guys tuning in and staying up to date with this. Hopefully I'm able to enlighten you a bit. I'm not an attorney. I'm not giving any kind of advice. I'm merely just covering this, lifting up the rocks where I can, and hopefully you guys are benefiting from this to a degree. So greatly appreciate you tuning in. As always, follow me anywhere, Bishop on Air, on Twitter, on X, on Facebook, on YouTube. You can also find me on Rumble, on Instagram. Posting to all these places is kind of tough. If you need the podcast, you could search that out as well. And it's something that we're doing each and every weekday morning. So I appreciate you guys hanging out. So again, bishoponair.com for all those links and more.